Welcome to Walzer Melcher's seminar on dealing with business interests during an economic crisis. And I appreciate you all joining us here. I see that we have a bunch of attendees adding on, so we're just going to give a moment for everyone to join us. We've been doing a series of these programs, and I'm really enjoying it a lot. And I appreciate the support of everyone watching it. I'm seeing some friends here, Art Grader, Courtney Shepard, Don Schweitzer. I mean, just John Tannenberg. I mean, really just some incredible people here in our community joining us. We have Lorna Riff, who's just a wonderful forensic accountant that we work with. People from my office, Marion Stanton, Robert Stanley, Peter Walzer, Tamara Trindade. So I just really appreciate Veronica Melamed. This is just so wonderful that everyone's here with us. So I appreciate the support, and we want to continue doing this. This program today is not on valuing a business, but it's on dealing with a business that we can't value and can't divide. And so we have these problems here because of the economy, where we're going to have assets in a case. The dominant asset may be a business, and ordinarily in a perfect world we would be valuing it and awarding it or assigning it to the operator spouse and giving an offset of community assets to the other one, and that way they can go on with their lives. But how can we value something right now in this environment? It's very uncertain, at least short term, trying to put a value on something. How can we have liquidity? Even if we agree on the value, is there liquidity for a buyout? Can we borrow money, or I'm sorry, can the spouse borrow money to fund that buyout? Maybe the other assets are depressed and it's not a good time to value or divide those. So we may be stuck in some cases in co-ownership hell. And I know that that's not what anybody wants. It's the absolute last resort, but it may be our only resort. And that is what this program is about. And we're going to go into some fantastic detail about this. My name is Chris Melcher. If we haven't met before, I am a trial and appellate counsel. And hot off the press, the California Supreme Court ruled today in the Brace matter, which was a case about joint tenancy property and whether spouses taking title to property in joint tenancy created equal separate interests or was community property. I was amicus counsel in that case. I got to argue that case in May, and the court just came out with the opinion, fortunately, saying, yeah, when you buy property during marriage as joint tenants, it is community. So that opinion is just out. I will be making it available, so super excited about that. If we haven't connected up on LinkedIn, I would really love to do that. It's a great community. We share a lot of ideas, and we're posting things about programs like this. You can also go to our website, walzermelcher.com/seminars, where we're showing all of the upcoming seminars, including one that Peter Walzer and Mark Stern are doing on June 29th, I believe, but you can check the date there on the site. That's an ACFLS free program on death and divorce. Such an incredible crossover program, so you don't want to miss that. There's other programs that are coming up. I'm doing another one Monday on spousal support, so I hope you see it there. And
I'm super glad to be co-presenting with Chris on this topic. I have handled a number of cases, family law cases involving business interests, and I think they're fascinating because you get to learn about so many different aspects that we don't always deal with, like taxation, the way entities are structured, et cetera. I'm Chrissy Djordjevich. I am a partner here at Walzer Melcher, and I'm excited to get started on this program. So first, we're going to talk about, there are three options for how to deal with a business interest in divorce. The buyout, a sale, or co-ownership. So buyout is the preferred option because there's a clean break and you can avoid ex-spouses having to be in business together. But this option requires valuation and equalization. Valuation is difficult in an uncertain economy because what's the value and is the value reliable? Equalization can also be difficult in an uncertain economy because usually a family business is the largest asset. So there may not be enough money, even in a normal economy at the time, to effect option short term. The second option is a sale. Similarly, maybe not the most that may be not the most ideal option in an uncertain economy because there may not be a seller that is ready, excuse me, a buyer who is ready, willing, and able. And also, a lot of times people don't want to sell their business interest because they've been growing it and developing it for a number of years. So it sort of leaves us with the third option, which is co-ownership, default option, which is, as we say, it's fraught with danger. And that's what we're going to focus on today, how to structure a co-ownership of a business interest between spouses after divorce. So while co-ownership is fraught with danger, it's important to remember that this is only a temporary measure that's going to be in place until we get to either a buyout or a sale. That's the end goal, until the business can be reliably valued or until there's enough cash to equalize the other spouse's interest and for there to be a buyout. So our goal will be to build a purchase option directly into the co-ownership agreement so that there will ultimately be a way out.
And so we're going to be going through, first of all these different options of co-ownership with the understanding, like Chrissy mentioned, that this is a temporary kind of a Band-Aid measure. It may be a couple years, but we're going to have an escape clause in there so these parties can get out of co-ownership through a purchase option. We could have funding of that purchase through distributions or excess salary, and that we'll talk about towards the end of the program. We're going to be mentioning the due diligence that's needed. What kind of investigation and facts do we need to get into an agreement like this? What are the limitations of co-ownership based on the way that this entity is structured and business partners that are existent there? So that is probably the most confounding part of all this, because some entities are easier to have a co-ownership with a spouse, added on or not added on, and we'll talk about all these things. Others are very, very tricky. Management and control, we're going to be going through that and how to compensate somebody for that. How does this agreement look? And taxes. Now, the thing to understand or keep in mind is that when you have ownership in a business, that can carry economic rights to get income from that business, but then also management and control. And those two things are separate. And in a classic like limited partner situation, we have all rights of management and control that are seated in the general partner who may not have any ownership interest in the entity. And then the limited partners are the owners. They're the passive owners. So that's the classic way of dividing rights of ownership between who is going to have the income and who is going to have the equity in this business versus who's going to manage and control it. So that's one thing to keep in mind, because through this process of temporary co-ownership, the operating spouse, if it was a business operated exclusively by one of them, is going to continue to be operated by that spouse. There's not going to be generally any kind of rights of management or control other than on gigantic issues like a sale or something like that of the business. So otherwise it's going to be the out spouse being passive and the in spouse being the operator, just like it was during the marriage, but now formalized in an agreement. We do have some businesses certainly where the spouses formed, operated, managed that together, and so there could be co-managers as well.
So we're going to talk about the three possible ways that ex-spouses can co-own a business interest. There's the in-kind approach, the holding company approach, and the nominee approach. And then we're going to talk about the due diligence required to make sure that the deal gets done right before you go into this co-ownership structure. So we'll start with the in-kind approach, which is the preferred approach. And here we would say, okay, there's one spouse who holds title to the business interest. We want to split that into 2 equal parts, one for spouse 1, one for spouse 2, so that each of them holds a direct ownership interest in the entity. And perhaps we would have a different class of equity for the second spouse with reduced voting or management rights. So we'll take a look at a diagram to show how that would work. So you've got the situation pre-divorce where spouse 1 owns 100% of the family business, and spouse 1 is also the manager. After the divorce, you split the 100% interest into 2 equal parts of 50% each. So each spouse holds direct title to the operating company, and the manager, spouse 1, continues to be the manager. But as Chris will tell us, this often cannot be accomplished because of the way that the entity may be structured and how co-owners may factor in, co-owners that are not one of the spouses.
That is the biggest limitation. If this entity is just owned by the spouses and there's no third parties involved, no problem. We can do that. We can have the in-kind division. We can protect our client if they're the out spouse by giving them an equity interest in this entity that's directly held by them as their separate property. But if there's third parties, they don't want new business owned. They don't want new partners. And so they're going to have to agree to it, or we're going to have to find a workaround. And that's where the meat of this program is on, because there's a lot of options that we have, even over resistant third-party owners. But, you know, certainly these bigger, more successful businesses, we're going to have other owners that we have to contend with. There's going to be a structure or a series of structures. And it seems like the more money these businesses make, the more layers of entities they have. They may have management and control in one entity, and they may have ownership of particular assets in other entities, all wrapped up into another operating company. So you can have multiple layers of entities, and we have to go through the operating agreements or shareholder agreements for each entity to understand what can be done, and not just assume that, hey, we're in divorce court and we have lots of powers and we can just force solutions. We have to work within the entity documents, and most of them have as a standard provision anti-assignment provisions, provisions prohibiting the introduction of a new partner or owner without consent of the others. So that's going to be a problem we're going to have to contend with, and we're going to have to know whether these other owners are going to consent to it. Now, I've had to negotiate these before and had to contact the other owners to see if they would agree to the introduction of this. And that can be a long process. Ordinarily, when I've reached out there, they're not that open to the idea of bringing somebody in who's getting a divorce with their business partner. That just sounds like a bad idea. And so they're going to be resistant to it, and they're certainly going to want it documented. And now who's going to pay for that? Who's going to pay for all those business lawyers to go through and redo all of these agreements? The business doesn't want to be involved in that. So a lot of times it's like a no thank you. So if we can't convince the other owners to admit our client as a passive economic only interest holder of the business, then we're going to have to look at how they're going to hold that economic only interest, and can we do that in a way that doesn't require the approval from the others.
So we'll move now to the holding company approach. So that means that we would be forming a new entity that would hold the spouse's interests, and that entity in turn would be the member, shareholder, or partner of the operating entity that we're talking about. So let's take a look at a diagram to show that. So here we've got the holding company in the middle that owns 100%, that owns the interest in the operating company. Manager, that spouse 1 continues to be the manager, and then each spouse has a 50% interest in that holding company. And I should say the manager of the holding company would be spouse one. So this structure is probably still going to need the consent of the other owners, the third-party owners of the business. But we like this structure because the holding company provides protections because each spouse owns a 50% direct ownership interest in the holding company. So if either spouse were to face bankruptcy or creditor collection issues, the other spouse's interest would not be impacted. So we like this.
And I think it's less offensive to the other owners of the operating company. So down at the bottom in that ugly kind of green color is the existing entity in which the spouse has a community interest in it. And right now, before they're just holding their direct member interest in it without their spouse being on title. And so all we're proposing to that other business partners is to say, hey, replace, where it says on there, Chris Melcher is the owner of 20% of this business. It's going to be the Chris Melcher Holding Company is going to be, now that owner, and that owner here is going to have all the same rights and privileges as anyone else had, and it's only going to be me that's going to be making the decisions. And so what's their problem? It's no issue for them at all. And then now we have this holding company who now holds the direct interest in the operating company, but the holding company is owned equally by these two spouses. And within that holding company, we can write all the protections and agreements we want about management of that holding company, compensation to the manager, fiduciary duties that they owe to each other, the purchase option later on. It's all in this document that we're creating. The other owners don't need to see or be concerned about it at all. And that's why we like this, and we think it's a realistic alternative.
So there are a bunch of different choices for the structure of the holding company, and each of these options, you can structure it such that the management rights in the entity are separate and apart from the ownership rights. So for example, limited partnership, very classic common business structure where the general partner manages and the limited partners own. Limited liability company, very easy to form. We see it all the time. There's a managing member that controls, and the members who own their interests don't control. You could set it up as a corporation. The spouses would each be shareholders, and then there would be a board of directors to govern, and you could determine who would be on the board of directors. Or lastly, you could create a trust. So the spouses in that scenario would be beneficiaries, and the trustee would have control for the benefit of the beneficiaries. However, as Chris will tell you, there are some limitations on what types of entities can hold ownership interests in other entities. So you got to watch out for that.
Yeah, this is a big thing that that caught me. And so we were negotiating. We had a divorce going on. Represented the client who was the out spouse, and there were a bunch of nursing homes, and there were a lot of them, and they were each set up as different entities, of course. And then there were some of those nursing homes owned they had the interest in the real estate in which the homes were situated, the businesses were operating on, owned by yet other entities. We had different mix of partners. We had different mixes of LLCs and corporations, and it was super complex. So my idea was to wrap all that up into a holding company for the spouse's interest, because there was no way that they could do a buyout at that point in time. And so it was going to be an in-kind division through a holdco. And so we were trying to structure that and negotiating it, and I kind of sketched it out like I did in that example in the graphic. And then we engaged a business counsel, and they drilled into it and said, look, based on this mix of entities, we cannot have a holding company that holds all these things. One of them was a captive insurance company too. And they just said, look, we can't dump all these assets, these business interests into this one holding company. There isn't one entity that can hold all of it. And then that's when I started learning about the limitations of what type of entity can hold another type of entity. Now, I'm going to simplify it because I don't want to cause kind of brain damage that I suffered trying to figure this out. But I think what the the easy way to understand it is that I don't think the IRS wants a passive company holding another pass-through company. So I kind of misstated that a little bit. We don't want one pass-through entity holding another pass-through entity. So that's what I kind of glean from all these rules. And so we've broken it down by the different type of entities. But so in this first example is the operating company, meaning this is the company that's generating all the money that one of the spouses holds an interest in, that's community, and we're trying to deal with it. And that company, let's say, is an LLC. Well, if we're using the holding company approach and we now want to create this new holding company, the H&W holding company, to hold one of the spouse's interests in that, the holding company can't be another LLC. It can't be another S Corp or a C Corp if the operating company is taxed as an S Corp. So basically, again, we can't have a pass-through entity holding another pass-through entity. So if that operating company, the underlying one that's community property interest in, is a pass-through entity, meaning that the LLC is a tax reporting entity, but it's not a tax paying entity. So it files a tax return, but the taxable income flows through directly to the owners, and that's picked up on their Schedule E of their individual returns. If it's that type of entity, it can't be held by another pass-through entity. So what our limitation then is to form really probably a C Corp or converted, and that's going to be very, very difficult. So that's going to really limit us. And I think the takeaway from this is, like, first of all, getting the mix of all of these entities, figuring out which one is which, not only what type are they as an LLC, but is it an LLC type taxed as a pass-through S corporation, or is it an LLC taxed as a C Corp that actually pays taxes, which is highly unusual. And then bringing in business counsel and figuring out, can we actually fold this thing up? Because the last thing we want to do is go ahead and write something up and then having business counsel later on telling us, or tax counsel, we can't do it that way. Now, if the operating company is an S corporation, again, the holdco can't be a partnership, C Corp, or multi-member LLC, but it can be held by a qualified subchapter S trust or an electing small business trust, which, no way I'm writing any of those. So we're going to definitely be bringing in business counsel to do that. And so again, it's so complex. It can be done, but it's very, very complex. And there's a question came in, is can we do this a revocable trust? And I think we're hitting that in one of the next slides. One of the things that we've done, I think it was one of Peter's cases, they had a corporation and husband and wife were involved in, and as we know, corporations are controlled by the board. And so what we could do is kind of realign the board seats and figure out who has control to pick board members. We could agree on the appointment of an independent board member. And so that one's the neutral tiebreaker that can't be removed, maybe except by court order. And so that way we're affecting management and control through the board with this independent board member without changing anything about the management structure, the entity structure at all. And so we're just not even creating the whole company. We're just saying, hey, we're just keeping all these shares in here, but we're going to have an independent board member. So that could be a last resort.
So one important thing to remember with regard to professional corporations, state law limits who can be owners. Only a professional of the type of corporation that it is can be an owner. So for example, here, if the cat is a surgeon and the cat as a surgeon owns a medical corporation, the cat's spouse cannot be an owner of that professional corporation unless the cat's spouse is also a physician. So just keep that in mind as you're thinking through the issues. So many times, because of all the issues we've been discussing, what we are left with is the nominee approach. So this is the one that scares all of us as family law attorneys because we prefer a clean break as much as possible, and we don't want a situation where spouse one continues to hold title to an interest on behalf of spouse one and spouse two. But however, it's simply required in certain circumstances when there are no other options. If you can't do an in-kind division, if you can't do a holding company approach like the one we just talked about, with this approach, like I said, the interest remains titled in the name of the operator spouse, spouse one, on behalf of both spouses, and spouse one then has a duty of accounting to turn over any income, turn over spouse two's share of any income that's derived from the interest in the business. And in most cases, this is the approach that we're unfortunately stuck with. So we'll take a look at the diagram. So here, you've got spouse one continuing to hold title in the operating company, in the underlying business, together with the other third-party owners. So then the question becomes, okay, when the company's getting ready to distribute income, how does it do that? So one option would be that you could potentially instruct the company to pay out distributions directly to spouse one and then to spouse two, his or her share, and then of course to the third-party owners. But the problem is with that approach, you will likely need to get the consent of other owners because it's an assignment, in effect, of spouse one's entitlement to the income. So the problem is that a lot of these entities have agreements that specifically prohibit, they have an anti-assignment clause built into the document, which says you can't assign your share of income. So if you've got an entity with that structure, and if the other owners will not consent, then you're left with a situation potentially where the company distributes to spouse one, and then spouse one, we're left to rely on spouse one to then turn over the share of income, required income, to spouse two. We don't like that. These parties have gone through a divorce. It's putting a lot of trust into spouse one. There's, accounting required. There's going to be a lot of distrust. Again, we're kind of dealing with the best of worst options here. But we may be able to get payment instructions, which we'll talk about, payment instructions directly to the entity to achieve the result we want, so that, at least the entity can be held accountable.
So this slide we're presenting in the context of a kind of post-judgment situation where we've divided up things and we're keeping the operating companies the way it is, and spouse one is going to remain on title as the member and subject to the obligation of the company to make distributions to spouse two for his or her share. But this can also work pre-trial, and we're going to spend a lot of time talking about this, and particularly the legal authority of the court to force situations like this, even when the spouse one or the third parties don't agree. And because our cases always took a long time, I mean, even in normal situation, we may be in a multi-year litigation in a big case. Now, with the courts being impacted so badly, it could go on even longer. And so if we do have a business that's throwing off a lot of money during the divorce while we're waiting for trial or settlement, do we trust spouse one just to receive the distributions, or do we want to go into court and ask for an order forcing the entity to make distributions directly to our client? So this segment of the program could be useful even pre-trial. Now, the problem with this approach is bankruptcy, because whenever the spouse, we're calling this person, holds 100% of the community interest in his or her name, their creditors can go after that. And so we don't want our clients' interest taken by spouse one's creditors. Now, if they're a community creditor, maybe that's going to happen one way or the other. But if our client has a 50% interest or whatever in there, we want to get that out of the other spouse's name and put into our client's name, so at least they're not subject to liens, judgment liens, and bankruptcies by the other spouse. So the only way you can really do that is to divide it, but like we've been talking about many times, we can't divide it. So this is an inherent risk that we want to be aware of and talking about, because that permission to divide things is often going to be denied. And I would mention, before I get into this remedies thing, that the family code and around the 900 section is where we have all the rules about the allocation of creditors' rights and when can a creditor go after one spouse for the debt of the others. So I would be looking through that, and post-judgment we have the most protection possible because there is no community property, it's been divided. So that's ultimately we want to get that level of protection. So now we're going to talk about really the important stuff. We're assuming that the entity agreement does not allow these assignments. And one thing, look at the fine print on that. I've seen some entity agreements where it says, hey, you cannot assign your interest to anyone, but maybe it sometimes we'll say, oh, but you can do it to a trust. And that's one of the questions that was raised earlier, is because it may allow the assignment to a trust. Well, gee, if that's and we have the green light, then we go put it in the trust, and then we form the trust in the way that we want it to be done, and there we go. Not as protected maybe as a formal legal entity, but it's pretty good. So look at the fine print on that. But let's say that this entity agreement doesn't allow what we want to do, and we're just going to go ahead and transfer it anyway. Super risky, because the agreement most likely says any attempted transfer is invalid, but also there could be repurchase options in there, and those are onerous. And so it could say, hey, if you attempt to transfer, or even if there's an involuntary transfer, meaning by a bankruptcy court or maybe a family court involuntarily transferring your stuff, the company can buy your interest for $1 or something like that, or for the capital account. So I'd look out for that, because we don't want to trigger something and then be responsible for it. So I would be cautious. Now, the courts can't just start changing stuff. Chrissy, what do you say about that?
So the question is, I guess, what can and can't a court do in a situation like this? So first, the court cannot change the entity agreement. And that's even if you join the entity as a party to the divorce action. A good analogy would be, okay, we join retirement plans to cases all the time. While we can divide things and direct payment, a court does not have the power to fundamentally change the terms of the retirement plan. So same here. Whatever we're going to ask the court to do has to fit within the construct of this entity, the entity documents, and how it operates. So,
And that's true even with the joinder. And that's the thing that I had to kind of work through, because it's like, wow, well, family courts are almighty. We know that. And then now this isn't just a third party. They're a party to the action, because we've joined them to the case. And now the court has jurisdiction over these third party owners, business partners, and saying, well, hey, we're just going to force you to do it. I don't think it goes that far. I think that the joinder is limited to protect the community interest. It doesn't give the court just to start changing agreements. And because in no litigation, I mean, can we do that? We enforce agreements in court, we interpret agreements in court, we say that they're invalid in court, but we don't just say, well, hey, this provision about assignment we don't like, and we're just going to allow assignment. That's reforming it, and that can only be done through a matter of interpretation when it's necessary to imply reasonable terms. But we can't just make up terms that are inconsistent with that. Courts have no authority to do that, even when a party's joined.
So what can a court do? So we know that orders can be made to protect the right to receive community income. And again, the courts can make these type of orders even without the third party being joined. So we have two examples of super useful code section, one CRC rule, where the court can issue relief even without the entity being joined. So under Family Code section 2045, this allows the court to make injunctive orders against a third party without joinder in a dissolution proceeding to protect the community interest. So this is a good mechanism to get some quick relief from the court without having to go through the joinder process, which can delay things. So, but 2045 does have, it's somewhat limited because it's limited on its face to injunctive relief necessary to prohibit transfers or other disposition of property, except in the usual course of business. So, but we also, though, have California Rule of Court Rule 5.18, which is broader than Family Code Section 2045, because CRC 5.18 allows other relief in addition to just injunctive relief. So that can be a super useful tool if you want to go to court.
And just to illuminate on that a little bit, I've received now several cases where I've represented a private equity fund that has invested in a business, and now one of the owners is going through a divorce, and there's all these issues swirling around regarding the business and wanting to join the business or add people, change agreements that have been made, all kinds of things. And so that's why I have these sections on here, because I dealt with them now several times. And one of the things is the classic move would be, by one of the divorcing parties is to join the other owners or the business into the action. And so what I've been using to resist that is these two, the Family Code 2045 and CRC 5.18, because 2045 says the court already has authority over third parties without joinder. And I thought that's pretty cool, because there you can now, if you're representing the third party target here, the company that now they want to have joined into their divorce action, we can argue, hey, leave us out of it. A divorce is between spouses and not with a business, and leave us alone. And you, court, family court, already have all the power you need under these two parts of the law, that you can make injunctive relief against us. You can prohibit transfers and dispositions of property without joining us. Leave us alone. And of course, the reason why we want to be left alone is that 2030, I think it's G, needs-based fees can be assessed against a joined party as to the joined issue, which is always why they want to join the business in, because the business probably has lots of ability to pay. And so we're just like, do not join us into this action. And so that injunctive relief, and now of course if we're the ones wanting the injunctive relief, this is also a benefit to us, because we don't have to go through the joinder process and say that, hey, this is some indispensable or necessary or convenient party. We don't even have to join them. We just go straight to a RFO seeking injunctive relief against the business under 2045. Obviously, you have to give them notice of that, but we can do that without joinder. So it's a pretty cool section. And that, as Chrissy pointed out, there's a subtle difference here. 2045 is very limited because we're not joining them. We can only do orders necessary to prohibit transfers or disposition of property except in the usual course of business. 518 says, or other relief. So maybe you could read into that to say, hey, maybe there could be even greater relief than 2045 allows. Now, so here's the other thing, the other little trick, which is a collection account management agreement. So remember, we went back to that other slide where we were looking at that graphic where we were saying, hey, we want the distributions that are attributable to the community interest in this business instead to be paid to all 100% to spouse one, to be divided 50% spouse one, 50% spouse 2, and just direct payments there by the entity. Now, another flavor of that is the CAM, and I learned about that through an entertainment case. And basically, in that case, there was a entertainment project that was producing lots of income, and my client had an interest in it, and his wife wanted a share of it. And so I started looking through all these documents, and I came across this CAM agreement, which I had never seen before, which I thought was very cool. And what that is that at the level, and this was a film, they have all of the people who are involved in that film as it's producing income need to be paid. And so you have rights holders and distributors and all these things. And so basically this revenues from the film were all being collected by a trusted person. And it's like an escrow. And so all of those revenues were directed there. And then the CAM agreement says, as you collect revenues, you shall distribute them in this way. And so I thought that was pretty cool. And so we can adopt that type of process here to say, hey, entity, as you're going to distribute money, you will distribute it, at least the part that's attributable to this spouse one, to this escrow officer. And it's a CAM, and you're just gonna pay it to them. And then we direct the CAM how to distribute it between husband and wife, or hold, or pay to lawyers, or whatever it's going to be. But it's going to go to the CAM, and then we tell the CAM what to do. Now, I think that we can force this. So if the company says, hey, we have a anti-assignment provision in there, so we're not going to honor the payment instructions by spouse one to pay 50% of that spouse's income or distributions from the entity to spouse two. We find that violates our entity agreement, so we're not going to follow it. Well, if that's the case, I think we can go to court and say we're filing a motion and under 2045 and 518 for relief against the entity to compel them to make that payment attributable to the spouse one's interest in the business to the CAM. And we would use if, as, and when language. And we would say, if entity, you're going to make a distribution, you will make it. As you make it, meaning the amount and nature of it is whatever you decide to do. But as you do it, you will do it to the CAM. And whenever you do it, at that time, you make distributions to anyone, you will make it to this CAM. So that does not intrude at all on the operation of the business. It doesn't tell the business to make distributions. It just says that whenever you in your discretion decide to make a distribution attributable to this spouse's interest, you shall instead pay it over here. That's not intrusive. And I think that that's necessary to protect the community interest in it, and we can get that injunctive relief. And so that's a great model to use. And it's also analogous to a charging order. So we've seen now, unfortunately, where we've had to collect on divorce judgments. And so we have a provision where like equalization payment to our client, and it's not being paid, and then we have to go collect on it. And we've been doing some enforcement work. And if that spouse has an interest in an LLC, for example, we can't tell the LLC to distribute the money out, but we can tell the LLC through a charging order, hey, if you ever make any distributions of whatever to this spouse, former spouse, you shall instead pay it over to us as a judgment creditor. That's a charging order. And so I have the authority for that there on the slide. So I think we can do this, and I think we should be looking at doing this. It's not for all cases, but if we're worried that, let's say pre-trial, that we can't trust this other spouse to make the distributions, to divide the distributions it's received, look at a CAM. This is the slide. Basically, we have spouse one as the owner, record title owner of part of the operating company with the third party owners up top. And then normally below that, we would have the distributions going to spouse one and the other owners. But now we've interceded here and put the CAM in between the spouses and saying, hey, operating company, whatever you were going to pay for spouse one, don't pay it to spouse one, pay it to the CAM. And then we tell the CAM what to do with the money. Clean solution.
So the next topic we want to move to is compensation to the manager spouse during the period of co-ownership. So in formulating this co-ownership, we are contemplating that one spouse is going to continue managing the entity on behalf of both spouses during a specific period of time. And that manager is obviously entitled to be compensated for his or her services and post-separation. And so it's his or her separate property. It is critical to deal with this upfront because, and you know, you can try to reach an agreement. You may need to get a reasonable compensation expert to opine or help you come up with what the reasonable comp should be. But it's critical to get this determined upfront in connection with the co-ownership agreement, because otherwise you are guaranteed to have a huge fight down the road, because the operator spouse will likely say, any income that was generated that came out of the business during this period was compensation for my services. There's nothing left over for distributions. You get nothing. Whereas the out spouse will obviously argue the opposite. So you can agree on a fixed amount, like a salary, or you can have a formula which provides for like an extra bonus amount based on the performance of the company. But it should be, like I said, agreed upon in advance, in writing, and be crystal clear. The other aspect to pay attention to is not to allow, excuse me, not to allow the operator spouse to be able to change his or her compensation. So you don't want to have a situation where you've done this co-ownership agreement, you've fixed compensation, and then the operator spouse goes to the entity and says, hey, give me a raise. And then you've got, you know, the entity agreement and entity operations, which are in conflict with the co-ownership agreement. One way of getting around that, I mean, is to, and I think one thing Chris has done before is to have a proxy. So in other words, the out spouse will have the proxy vote for any vote that deals with the in spouse's compensation during the co-ownership period. So it's important to think through all these different issues. So because you're running in parallel between the co-ownership agreement and the entity operations, just to make sure everything is consistent, everything is on the same page, and there's not some kind of conflict or workaround that's going to end up prejudicing the in spouse, excuse me, the out spouse.
So now we teased at the beginning about this is temporary. It's a Band-Aid solution, and we're going to have a option to purchase out, buy out the other spouse, usually baked into this agreement. So it might say, hey, we're going to be in this co-ownership thing here for 3 years, and at the end of 3 years, there'll be an election or option by spouse one to purchase spouses two's interest for $1 million, let's say. And that could be exercised at any time before then, and or not. Or it could say that there will be a buyout. So at the end of the year, there shall be a payment of $1 million. And we could have installments along the way. And then by the end of that period of time, it's done and it's paid for. So we contemplate, hopefully, that this business is going to be spitting off some income that's in excess of this reasonable compensation amount. And we're going to be dividing that excess distribution or income equally, or on whatever percentage these spouses have an interest in it. Now, one thing to look at is if you have this repurchase option baked in, is then to allocate part of those excess payments to go towards the promissory note or obligation to buyout. And that way we know it's being funded and there's not this gigantic balloon payment at the end. So for the example is that if there's $1 million that's due to wife in 5 years for her interest in the business by husband, and we've agreed that the salary is $300,000 off the top for reasonable comp, and that goes to the husband for management and operation of the company, we could say, well, hey, the next $200,000 will go to him as profit, so he gets some money to live off of, but anything over $500,000 for his interest in this company would then go towards the payment to wife and would go to her to kind of pay that thing down. Now, obviously, there's going to be a support interplay. So if we're setting salary at $300,000 for a husband, then there's going to be support potentially due on that, and we could figure all that out when we're setting it. So we could set a lower amount of support so that there's no at least spouse support on that. We can fairly easily waive the rights of spouse support. We can't really waive the rights of child support on it. So we'd have to figure out, hey, there's going to be some child support if there's minor children on that income, just something to think about.
So the next question is, what are the duties of the manager spouse to the other spouse during this period of co-ownership? So as we know, fiduciary duties of spouses apply to one another with respect to community property until the community property is divided, and that's pursuant to Family Code section 1100E. So the question becomes, pursuant to any of these co-ownership approaches, has there been a division of community property such to keep the fiduciary duty in place or to have it terminated? Ultimately, it doesn't really matter at the end of the day, because you can provide for a duty of care and loyalty by contract, and for a fiduciary duty by contract. So here, either way, what you should do is in the co-ownership agreement, you can include language saying, look, our intention is for the fiduciary duty to apply with respect to the community property, interest pursuant to 1100E. But in the event that it doesn't, we are providing for a contractual duty of care and loyalty, so that there is a fiduciary duty of care and loyalty, so that there's no confusion about the fact that that still exists. There are differences between the duty of care and the duty of loyalty. Duty of loyalty is a faithfulness to the purpose of the contract, not to lie, cheat, and steal from the other spouse. And there are probably some disclosure obligations built into that as well. The duty of care involves decision-making by the manager to act, with ordinary care on behalf of the entity. The manager will typically also be protected by the business judgment rule that protects decisions that are made sort of with ordinary care in the ordinary course of business. So, what we want to think about in coming up with the co-ownership agreement are what kind of decisions can be made unilaterally by the manager spouse? What kind of decisions require the consent of the out spouse? We should spell that out just like any good, partnership or business, any other entity document would do. And the Uniform Partnership Act may be a place to start to look through there for, how to kind of lay this all out in the context of a co-ownership agreement, those decisions that can be made unilaterally versus those that require consent. The other thing is that all contracts have an implied covenant of good faith and fair dealing built in. So that's an added protection here as well. So, if a spouse, if the manager spouse is acting in some kind of bad faith or doing something to frustrate the purpose of the contract, that can be actionable as well. So we're going to move now to due diligence, which is actually something to consider at the very outset of all of this, but we've saved it for the end. And it's critical to do your due diligence to make sure that everyone is going into this co-ownership structure with eyes wide open, knowing everything there is to know about the business and what could come up. So very important to engage a business attorney early in the process. We are family lawyers, not business lawyers. Most of this falls into business law, not family law. It's great to be able to issue spot, to know these things exist, but you're going to want to engage business counsel to probably do some of the heavy lifting on some of these items.
And we'll start moving through this a little bit quicker just for interest of time, but there's a pretty kind of obvious list of documents here that I've listed on this slide: buy-sell agreements, entity formation agreements. Guarantees are super important, because did our client personally guarantee a lease or a loan for the business, and are they going to be stuck with that? If there's a breach and maybe, on their own assets maybe being now taken by that creditor, and we're left with some indemnification provision against the other spouse. So of all those on the list, I want to see, what did my client personally guarantee? Also, different classes of voting. I saw in one case that I had recently that, and this is a huge, huge company, and he had buried into fine print a very, very significant right to control the corporation. And it was very hard to find and understand. But once we saw it, it's like, wow, this is super control built in there, even though his percentage interest in the company wouldn't reflect that he would have the right to control the board, but he did. Again, on creditors, Chrissy, what are your comments there?
Super important issue, but just basically know who they are. Who are they? What's owed? How are they secured? Are they secured through business property or other personal real estate? A lot of this is going to be obvious when you go through the entity, documents, because you'll see loan agreements, you'll see payments to creditors. But some things not to forget. Don't forget landlords, because a lot of leases for businesses will have a personal guarantee from an owner of the company. So if a spouse has given a personal guarantee, this could have huge implications in the event of a default. The other thing to not forget about tax, not just federal and state income tax, but also look to issues like sales tax, payroll taxes. These are significant, and the business attorney could assist, in advising on those. Covenants against transfer assignment. So this could come up in the context of loan documents. Sometimes loan docs will say, the structure of this entity cannot change, while this loan is in place. You may need to get lender consent before taking any action if that's there. And then obviously you're going to want to know about any litigation or potential litigation threatened against the company.
And also looking like I had a restaurant business involved, and there were hundreds and hundreds of thousands of dollars of liability that my client suffered from personal guarantees to landlords, and on the payroll tax that wasn't paid by his wife, and on the liquor license. So we've got to look at all that stuff. Again, we're just going to move through this pretty quickly, but obviously when we do disclosures, we're going to understand, like, hey, is there any contemplated sale or financing of this business going involved? Non-compete. I have an article, it should be in your materials on the share file, but I wrote an article for ACFLS on non-compete orders that the court can make against a spouse over their objection. And so they can't compete with the business that's being awarded to our client. If say if there's a traditional buyout, we don't want the other spouse competing. So there's authority there to get a non-compete, even over their objection. But if we're doing this by agreement, we'd also want a non-compete, because we don't want to say, hey, we just bought this thing, and all of a sudden now the spouse who knows the secret sauce is going and competing with us. Super important. Security interests. One thing is looking at a quadro, because maybe the big asset in this business, in this estate, is the business, but maybe there's also a big retirement account. And we can use the retirement account to secure a buyout or equalization. And it's pretty cool. So this is authorized. And so basically we would have, and I'm just doing this in a very simplistic way, but say there's $1 million in a retirement account, and we're going to do a quadro for our client's 50% interest. So he or she's going to get $500,000 into her rollover IRA. The other $500,000 is confirmed to the other spouse, but they owe us money. They owe our client money. So what we're going to do is another quadro is security on that, and it's a conditional quadro. It says, if you, spouse, do not pay this money that's owed as an equalization, then we are directing, and we would need a further order to show the breach, but the court will then direct the administrator to pay over that other $500,000 to us for the money that was owed. So look into that. Obviously, it's a quadro lawyer that would be involved.
Last slide, the issue of taxes, always something important to consider. So we're all familiar with IRC section 1041, which deals with non-recognition of gain or loss in connection with a transfer made incident to divorce. So we know it's protected, and that if the transfer occurs within 1 year of the termination of marriage, you're covered. Here with this co-ownership structure, we're probably going to be going long beyond the year. But also, alternatively, it's presumed, the transfer is presumed presumed to be related to the cessation of divorce if the transfer occurs within 6 years of divorce and if the divorce instruments require, the transfer. Here in our co-ownership agreement, we will, that will be the divorce instrument. We will spell this out, that the intent is to be covered under section IRC 1041, that it will not be taxable. If you get beyond the 6 years, you can still rebut. There is a presumption that IRC section 1041 does not apply, but you can still rebut the presumption by laying out the facts as to why it was impractical for the transfer to have occurred within the 6 years. So you could use some of the things we've discussed today to kind of lay out why that couldn't happen, and you could try to rebut the presumption.
So that brings us to the end of the program. I hope you got value out. I know we covered like a ton of stuff. And this is what's so cool about our job, is that we get to be involved in so many different aspects of the law. Most all this was corporate law, business law, a little bit of tax. So, that's what keeps me engaged and interested, because it's like we get to learn about all these different facets. So I hope you're finding value. I hope you love this stuff. We want to continue providing these programs. In the email we're going to send out as a link to go to our Google review. If you could give us a Google review, it just means a lot to us just to see your comments. It helps us out a lot. If you have the time, please follow that link, do a Google review. We have these upcoming programs. Monday is going to be on spouse support. On the 29th, Peter and Mark Stern are going to be doing death and divorce. Those are also free programs. So I hope you're getting value out of that. If you ever have any questions, contact Chrissy or I. We totally love to talk it out and also learn from you. So with that, I hope you stay safe and have a great day.